You know, from our cars and smartwatches to our refrigerators and even massive industrial machines, we are just surrounded by things generating a total tidal wave of data every single second. But here's the question. Who actually owns all that data? Who gets to use it? Well, the European Union has just rolled out a huge new rulebook called the EU Data Act to answer exactly that. So let's dive in and break down what this new law is all about and what it really means for you. I mean, really think about it. Your smart car is logging everything. How you drive, how the engine is doing, where you go. Is that data yours? You bought the car, right? Or does it belong to the company that built the car and its software? That's exactly the question at the very heart of this new EU law. Okay, to get our heads around this, there are two key terms you've got to know. First, a connected product. That's basically any gadget that creates data about how it's used or what's going on around it. Think smart thermostats, fitness trackers, you name it. And second, the data holder. That's the company, usually the manufacturer, who controls all that information. Think of them as the gatekeepers. These two are the main players in this whole new game. To really get to grips with this, we're first going to look at why this law was needed in the first place, what we'll call the locked data problem. Then we'll see how it's designed to put you back in control. After that, we'll explore how it levels the playing field for businesses and even makes it easier to switch cloud services. And finally, we'll zoom out and see what the big picture is for Europe's digital future. All right, so first up, the locked data problem. I mean, why did we even need a whole new law for this? Well, before this act, the whole data situation was, frankly, a mess. No one was really sure who owned what. So all this valuable data just stayed locked away in what you call data silos, and only the manufacturer could get to it. This created this huge power imbalance where small businesses and, regular consumers had basically no say and no way to access data from the very products they owned. And this slide really nails the fundamental shift. Before the Data Act, the data holder, the manufacturer, held all the cards. They had exclusive control. But after the Data Act, the power shifts right back to the user. That's you, the person who actually owns or leases the product. You now have clear rights to get your hands on that data and decide who to share it with. So if that was the problem, what's the solution? Well, it all boils down to two simple things: your data and your control. Now, this is really interesting because this quote gets right to the core philosophy of the law. The EU's position is pretty straightforward. Since the data is just a digital record of your actions with your device, well, it should be accessible to you. It sounds simple, but it's a massive shift in how we think about who owns data. So, how does this actually work in practice? It's pretty much a simple three-step process. You, the user, just make a request for your data. The data holder then has to give it to you, easily, securely, and for free. And here's the game changer. You can then take that data and share it with a third party. Imagine getting your car's performance data and sending it to any repair shop you choose, not just the expensive dealership. That's the kind of power this law unlocks. But, and this is a really important but, there's a vital protection for the manufacturers built right in. A third party, like that independent repair shop, can't just take your car's data and use it to reverse engineer their own competing car. The point here is to spark new services and better repairs for the products you own, not to help someone steal a company's design and build a knockoff. And this isn't just about consumers, not at all. The Data Act is also trying to create a much fairer marketplace for businesses, especially when they're making deals with each other. So you know those crazy take-it-or-leave-it contracts that are completely one-sided? The Data Act is putting a stop to some of the most unfair clauses. For example, a company can no longer slip in a term that says they're not responsible for massive screw-ups, or a clause that gives them the sole power to decide what the contract even means. That's out. Instead, the new gold standard for all business-to-business data sharing is something called FRAND terms. That stands for fair, reasonable, and non-discriminatory. It basically prevents big data holders from playing favorites, giving sweet deals to their partners while charging crazy fees to competitors. It's all about leveling the playing field. Okay, next up, the Act tackles a huge headache that I'm sure many of you have felt: getting locked into a service. Specifically, it's going after vendor lock-in for cloud services. Yeah, one of the classic tricks to keep you from leaving has always been charging massive fees to move your data. Well, the Data Act is putting an end to that. As you can see on this timeline, those charges are already being phased out, and by early 2027, they'll be gone, completely prohibited.
And it's not just about getting rid of the fees. Cloud providers now have a legal duty to actually help you switch. They have to provide real assistance to make sure your data gets moved over correctly so you can achieve what's called functional equivalence. In plain English, that means they have to help make sure all your stuff actually works properly after you've moved it. It takes a lot of the risk and fear out of switching.
So we've talked about you, we've talked about businesses, but what about the public good? What happens when a government needs to access data from a private company to deal with a major crisis, like a natural disaster? Well, the Data Act has rules for that too. Now, let's be clear, this is not some open door for government snooping. The rules are incredibly strict. They can only get access when there's a true exceptional need, like a major public health crisis. The request has to be super specific, they have to try using non-personal data first, and critically, they have to delete the data as soon as the emergency is over. These are some serious safeguards. Okay, so for our last section, let's zoom all the way out and look at the big picture. What's the real endgame for all these new rules? What's the grand plan here? When you put it all together, it really comes down to this single vision. By empowering us, the users, with real control, by breaking down those data silos to increase competition, and by sparking all kinds of new innovation, the EU is trying to build a digital economy that is just fundamentally fairer and way more dynamic. And the big question, when does all this actually happen? Well, go ahead and mark your calendars. The vast majority of these new rules will be in full effect across the entire European Union on September 12th, 2025. So, to wrap it all up, what are the key things to remember? First, you are getting way more control over the data from your smart devices. Second, business contracts for data are about to get a whole lot fairer. Third, switching cloud providers is going to get so much easier and cheaper. And when you add it all up, this isn't just another regulation, it's a whole new framework designed to kickstart innovation all across the EU. But of course, the billion-dollar question is what happens next? Will unlocking all this data really light a fire under European innovation like they hope? Or are we about to open a whole new can of worms with endless disputes over data access, privacy, and trade secrets? I guess only time will tell.